Hello guys, welcome to our new page Lawyers Corner. This page is created for spreading legal awareness in our society. For any kind of legal assistance, feel free to send us email. Those who are new, please subscribe, follow our page. Today we will discuss about a new topic named Epistolary Jurisdiction. This is a rare kind of jurisdiction of the High Court and Supreme Court. The concept of epistolary jurisdiction first came into force from the judgment of Fertilizer Corporation Kemgar Union versus Union of India's judgment. From this judgment, the terminology public interest litigation was used by Honorable Supreme Court Justice Krishna Iyer. In this particular judgment, he used the expression epistolary jurisdiction. This is the jurisdiction of Supreme Court for exercising its inherent power to uphold the human rights of the poor. This has its qualifying characteristics from the jurisdiction known as suo motu, as also PIL. On being apprised through any means, either through newspaper feature or through news item from a letter, even transcript upon a postcard, telegram, or by an oral information laid before the judge, the superior court may exercise such jurisdiction, which meanwhile styled as epistolary jurisdiction. The adjective epistolary has its genus in the word epistyle, which means any of the letter in the New Testament of the Bible, and as such the adjective epistolary generally manifests an expression made in the form of letter. Through a letter, this jurisdiction of the higher judiciary can be invoked, but certainly that must be connected with question of upholding human rights. The Indian Constitution in its Article 39A empowered the High Courts of India to exercise epistolary jurisdiction, which provides equal justice and free legal aid. It states that the state shall secure that the operation of legal system promote justice on the basis of equal opportunity and shall in particular provide free legal aids by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Supreme Court of India in a number of cases acted on a non-formal petition, specially letters sent to the court by any person or organization engaged in the cause of upholding human rights, treating the letter as a writ petition. One of such is the case of Bandhu Mukti Morcha versus Union of India, AIR 1984, Supreme Court 802, which is known as bonded labor case, where Supreme Court helped to secure the release of bonded laborers. The hurdle that petitioner has to face initially in this case is the question of locus standi of Bandhu Mukti Morcha, that the said organization, not being directly aggrieved with the old bonded labor system, not entitled to invoke the writ jurisdiction of Supreme Court, even though formal petition, not to speak of through informal letter. Their lordship examined the relevant provision of Article 32 and found that no specific method for proceeding has been provided involving the writ jurisdiction of the Supreme Court, and as such Supreme Court of India is empowered to initiate writ proceeding either through formal or informal petition. In another case of Sunil Batra versus Delhi Administration 1978, the Lordship of Supreme Court, Justice V.R. Krishna Iyer, Justice R.S. Pathak, Justice Reddy categorically opined that mere technicality cannot be bar initiating writ proceeding when the same involves a habeas corpus matter, their lordship expressed the view that the court shall uphold the human right of the prisoner by exercising its writ jurisdiction when information reaches the court by any manner. In the year 1986, the Chief Justice of India formulated a number of principles to be followed in exercising epistolary jurisdiction. The principles are: to invoke epistolary jurisdiction, informal petition by way of letter, telegram, or by laying information before the court must be addressed to the court and not to a particular judge. Secondly, informal petition containing allegation regarding violation of human rights should only be treated as a writ petition when such informal petition is preferred on behalf of a social in advance people or class of people, when such people or class of people suffers from any sort of disability, monetary or physically, especially when such person is a detainee. Thirdly, there should be a public distress cell within the Supreme Court administration which will consider this informal petition and send the same to the appropriate bench for consideration of the same as read by the judge by their leave. Fourthly, when any such informal petition on behalf of people is taken as a writ, general notification in the newspaper must be made allowing impleading parties in the writ either in favor or against the case. Fifth, the court appoint amicus curiae in the case and on the public hearing decide the matter. Sixthly, if any of judge desires to act on any information published in the newspaper, he must act through the Chief Justice. So here the Chief Justice of India made some guideline so that the power given by epistolary jurisdiction may properly use and there may not be any miscarriage of justice or undue advantage of any person or institution through this epistolary jurisdiction. Lastly, in a very sensationalized present case, which is Unnao rape case, Supreme Court used the epistolary jurisdiction upon a written letter of the victim. This is the basic concept of epistolary jurisdiction. Thank you for staying with us.